My lords, my lady, I have 3 points in reply on the issues of law that were canvassed by Professor Bailey. Now, first, with the greatest of respect to the learned professor, a number of his submissions were confused and on some issues incorrect. Now, the first point is this. Mr. Bailey, sorry, I beg your pardon, Professor Bailey.
Well, I'm not sure whether we call him Mr. or Professor. I know he is a professor. There's been some discussion within the Court of Appeal about people who are professors or doctors or whatever, and I think, no disrespect, I think we call him Mr. Bailey.
Indeed. So the first point is he made some submissions about what amounts to consensus, and obviously that's a ground 2 issue and one that I made submissions on Wednesday. Now the context, just to remind the court, is consultation. We're dealing with the first part of the 3 limbs of a concerted practice, just the consultation part. And that requires 2 ingredients. The first ingredient, in an information exchange context, first ingredient is communication by A of information which substantially reduces or removes B's uncertainty about A's conduct on the market. So that's the first ingredient, and that's the bit where Mr. Bailey strayed into the facts, and I'm not going to address that.
There has been some reference in the cases to capable of removing uncertainty. That wasn't a term that Mr. Bailey used.
No.
And you've not used it either.
I don't use it. In my submission, nothing really turns on it, because if what the information does is it is sufficiently informative as to strategy, then it's certainly capable of reducing uncertainty.
Okay.
And indeed, it also reduces uncertainty. I'd say the two, in this context, it doesn't really make any difference between those two. So I don't need to make a particular point of it myself.
No.
So coming back to my response to Mr. Bailey, there are 2 ingredients. That's the first ingredient. That's the information bit.
Yeah.
And the second ingredient is acquiescence by party B in the form of accepting that information so that there is consensus between A and B. I'm discounting here where B actually requested it in the first place. If B requested it in the first place, there doesn't need to be the further bit, because we've already got the consensus from the fact that they requested it. Now, the submission that Mr. Bailey made was that if the communication from A to B doesn't satisfy the test for reducing uncertainty, well then silence by B cannot amount to consensus. Obviously we agree with that, but that's really a statement of the obvious. If you don't have the first ingredient of the mix for consultation, you're never going to have ingredient 2.
No.
But then, he then went on to apparently advance 2 inconsistent propositions. So first, I think it was in response to a question from my lady, he said that whether consensus is a matter of, consensus is a matter of fact to be determined in context. Now, we agree with that. That was very much the thrust of the submissions that I made on Wednesday. But then he also said, seemingly as a corollary to his point about what happens if you haven't got the first ingredient, he said, if you have got the first ingredient, so A did communicate information to B, which substantially reduced B's uncertainty, then silence always satisfies the requirement for consensus. And there are several problems with that submission, which seem to be the submission he was making. Firstly, the 2 different propositions that I understood him to make are incompatible. Either it's a matter of fact to be determined in each case depending on the context, or there is an absolute rule that wherever the first condition is satisfied, silence means that the second condition is satisfied. It can't be both. It's the same fallacy, in fact, that Phones for You fell into in their submissions.
But the cases don't support it anyway, do they? I mean, the cases support that if you've got ingredient 1, ingredient 2 may be sufficient, depending on the circumstances.
Exactly, it all depends. I took the court through on Wednesday the case law, which shows it all depends on the circumstances. The mere fact that you've got the first ingredient and you've got silence does not mean in every case you've got the second ingredient. In some cases, it will, of course. In many cases, in fact, it will, but in some cases, it won't. So that's the first point, and my lord, you well have that. Indeed, it's underscored by the fact that the implication of Mr. Bailey's submission would be the same as made by Mr. McLean, that you always need public distancing, and I showed you the case law on that, which shows that that's wrong for total marketing, for example, and it's inconsistent with the Advocate General in their Turas that we went to. I don't think I need to go back to that. It's inconsistent with Argos that we also went to, and it's referred to by the judge in the judgment, in particular, the judgment, paragraph 216. So that's the first error. The second error in the submissions is that he submitted that if there is a failure to publicly distance in a case of consultation, then the consequences for liability are exactly the same as if there were a failure to publicly distance in the context of an agreement. Now, that is wrong, and it is inconsistent with the concession that he also made on Eturas, on his feet, where he clarified an error in the CMA's submissions. And if we could please turn the CMA submissions up at page 1000 of the core bundle. I think it's 1000. Oh dear, no, it's not one. Yes, here we are. And if you could go to 63, please. Could you show 63? So this is in the context of the Anic presumption. That's the section of the submissions here. And in his submissions, written submissions, the CMA advanced the proposition that they agreed with TFEU that public distancing constituted the only means available to an undertaking involved in an anti-competitive meeting. And that is in the context of the Anic presumption. It is not in the context of the first presumption. Now, he has done a 180 degrees on that. I'm very pleased about that, because he was wrong, and he now agrees with me about what I say about that and Eturas. But there is an implication that follows from that, which is this. What Mr. Bailey has overlooked is that in the context of a concerted practice, participation in the consultation is not the end of the story. Because if you find that you are going to be held to have participated in consultation, for example, if you're at a meeting and the A and B concert and you're there and then you're dragged in, that's not the end of the question of liability, because you still have the opportunity to demonstrate that the Anic presumption should be rebutted. You are still entitled to come to the court and say, okay, I was part of the consultation, that's bad, but in fact I can still prove to you that there was no relationship of cause and effect between the consultation and my conduct on the market.
Yeah, so that was clear from the Tesco quote.
It is.
Because on the facts of the Tesco case, they may have been anti-competitive conduct and participation in consultation, but it didn't actually have any effect because the information in question was in the public domain before they could do anything about it.
Yes. So exactly, and that's why Mr. Bailey is wrong to say there's no difference because he mentioned the word liability, no difference in relation to liability as between the implications of failure to publicly distance in the context of an agreement and failure to public distance in the context of concerted practice. Because if it were an agreement, you don't have the other escape clauses. If you partake in an agreement, that's it. That your unlawful conduct has crystallised the moment that you have agreed something anti-competitive.
Sorry, it's just so I'm clear. The Anic presumption is relevant to concerted practice.
Only.
Not agreement.
Yes. And then the third error in the CMA submissions relates to the citation of Advocate General Cocott's opinion in T-Mobile. And could we go please to the authorities bundle? It's tab 44, it's page 2597. And she explains, I think it's 54, yes, Advocate General 54, halfway down, simply when one undertaking a loan breaks cover and reveals to its competitors confidential information concerning its future commercial policy, that reduces all participants' uncertainty in the future operation of the market and introduces the risk of diminution of competition, etc. And Mr. Bailey made much of this case for our case. There are a number of points to make here. First, if it's intended to suggest that the first limb of a concerted practice is made out simply when one undertaking breaks cover, well, that, for all the reasons that I've just been making, is wrong. And in relation to this case particularly, first point to make is that if we go to the judgment at page 2611 and look at paragraph 12, this was a classic cartel case where representatives of mobile telecommunication operators in the Netherlands held a meeting at which they discussed, inter alia, the reduction of standard dealer remunerations for postpaid subscriptions, which should take effect on or about September 2001. And confidential information came up in discussions between the participants at the meeting. So this doesn't appear to be just a classic unilateral disclosure case. So it's not quite evident why Advocate General Cocott is framing her point in relation to that. It certainly wouldn't seem to be anything other than some sort of obiter comment. And although the court does endorse her opinion in several parts, it doesn't endorse the particular part that Mr. Bailey referred to. Second, her opinion doesn't engage with at all the requirement of acceptance, whether tacit or otherwise. And of course, that's the whole issue that I've been arguing about under ground 2. So it simply doesn't take us any further forward on that crucial issue, and therefore the context in which it was being cited in my submission by Mr. Bailey was unhelpful.
So it's ground 1, not ground 2, isn't it?
Yes.
You said ground 2.
So I'm saying in a ground 2. I beg your pardon. Yes, I'm getting a little tired now at this stage. Yeah, okay. Yes.
You're talking about ground 1 of the appeal.
I'm talking about ground 1. I'm talking about the consensus
We're
part.
talking about whether there was consultation.
Yes. I beg your pardon. I'm talking about the consensus part. The second part. My second.
There has to be. Your point is a simple one, that there has to be acceptance, even if it's tacit acceptance, in all the circumstances.
Yes, quite.
And that bit of her opinion isn't really.
It's just not grappling with that. And of course, that matter depends on all the circumstances. Depends on the context. For all the reasons that I have already submitted.
And you're putting your case in a nutshell. Really, all of you say, in the circumstances of this case, let's say, on the facts as found by the judge, this is not a case where tacit acceptance leads to consultation.
Yes, and indeed, I obviously made my submissions on Wednesday, which I'm not going to traverse, about how the first limb isn't satisfied, the first ingredient isn't satisfied either, as Ms. Hoskins did. But this is all in the alternative, even if we're wrong on that.
Sure.
I understand that my learned friend has a further point to make in reply.
It's half a point, my lord. Mr. Bailey took you to the Tesco case in which the Anic presumption was rebutted because the information had become public before it could be used. And I suspect, my lord, the Chancellor has this point already, but That's a close legal precedent for the point I made yesterday in relation to Hum and Castillo, being that if, contrary to the judge's findings, Miss Castillo had told Mr Hum
It was too late.
that O2 was going to come out of TFEU completely, that fact became public before Vodafone.
Before anybody was doing this. Yeah.
Okay. And I really sat down before asking the court whether I could be of any further assistance.
Thank you very much, Mr. Thank you. Right.
My Lord, I'm going to let Mr Draper respond to Mr Hoskins' ground 7 point, with your permission, so I can have a clean run through on the...
Okay, is Mr Draper going to do that first?
Yes.
Yeah, sure.
My Lord, my Lady, there are 4 points from Mr Hoskins' submissions that I'd like to deal with by way of reply. The first was his pointing out that there was not a total failure of disclosure, that some documents were retained and were capable of being searched, and there was in fact some disclosure. He said that the fact there was such little disclosure, and you'll recall the example I gave of only 389 emails, as contrasted to around 74,000 in the case. He said that inferentially, the reason for that was because the people at Telefonica simply weren't involved in the decision-making. 3 points on that. First, we know that Miss Castillo was obviously sufficiently interested and engaged that she was seen by Mr Hum as an appropriate person to approach with a question as to O2's attitude to its exit from Phones for You in September 2013. Second point, and in fact the judgment is replete with references to Telefonica, including very senior executives within Telefonica, being deeply interested in and involved in decision-making around supplies to indirects in the UK. I'll just give you the references. You can see that, my lords and my lady, from paragraphs 256 to 270 of the judgment. That's in relation to decision-making in 2013. And also, in relation to decision-making in 2012 and the provisional decision to exit, you can see that from paragraphs 106 to 146, pages 290 to 304 of the judgment. There is extensive involvement from Telefonica Europe. If I could just show you paragraph 106, which is at page 290. You could just read that, please, to yourselves. That is at least part of the explanation as to why, when you look at the contemporaneous documents and you look at the judge's account of what happened, Telefonica is all over O2's decision-making.
Yep.
My third point, in that context, is wholly unsurprising that this was not something said by the learned judge when he came to consider the question of document destruction. Indeed, as I showed you in opening, paragraph 59 of the judgment, at 277, please, the judge in fact accepted that it means that some of the documentation which may well have existed is missing for one particular aspect of the claim. The learned judge certainly did not proceed on the basis that there was no disclosure to be given because the relevant individuals were not engaged with or involved. The second point that Mr Hoskins' case he made is that the judge considered the question of deliberateness. He said the judge did not conclude that this was deliberateness of the very worst kind. He referred you to Hollander for the proposition that there are effectively gradations of deliberateness. If this was not deliberate destruction of the very worst kind, it was quite close to it. It was very much at that end of the spectrum. A firm distinction between sins of omission and sins of commission is wrong for the reasons that I gave when opening the case on this ground. A deliberate decision to allow documents to be lost or destroyed is right at the far end of the spectrum of culpability.
And what it amounts to is this, isn't it? Is this what the evidence shows? That they didn't think that TFEU's case as set out in the letter before action was a good case, so they didn't bother giving any instructions to people to preserve documents?
Well, that's what's said at third hand through Miss Bridge in
Yes.
the witness statement that she provided.
Yeah.
Obviously, we weren't in a position to test whether that fairly unlikely explanation was the true one.
Well, but in terms of deliberateness,
Of course.
that's pretty serious. I mean, it may not be, you know, you get the letter before action, you think, oh, I better destroy that bunch of emails that I've got sitting in my computer. But what it does amount to is, well, as the judge put it, an arrogant disregard of the seriousness of the allegations.
Yes, there are probably 2 points, and I rolled them up into one. The first is, do we accept that that is the true explanation? We say far more likely that the true explanation is that there was a concern that the documents would be more likely to assist TFEU than to assist Telefonica. And if we had had someone to cross-examine, that's the case that we would have put. But a second point that responds more directly to my Lord the Chancellor's question is, it was clearly deliberate in the sense of intentional. They clearly intended not to preserve, and therefore to lose or destroy relevant documents. The submissions that I made in opening addressed what state of knowledge has to come with that intentional act in order to qualify as deliberate. I have my submissions on that.
Yep.
The second point on this is that the judge, it's important to recall what the judge in fact did. He did not proceed on the basis that this was deliberate destruction, but not of the very most serious kind. He proceeded on the express basis that this document destruction, as regards Mr Alieta, was innocent. We can see that from paragraph 58 of the judgment. This is where, as I showed you, the learned judge accepts Mr Alieta's evidence as to his own state of mind. And he says, I accept that, but it does not mean that relevant documents may not have been destroyed innocently. As I said in opening, in circumstances where the relevant party, Telefonica, Mr Alieta is not the relevant decision-maker, where the party intends that documents be destroyed in knowledge of a claim, that is deliberate destruction. The third point I wanted to respond to is where, in argument, in discussion with Mr Hoskins KC, my Lord the Chancellor drew attention to paragraph 303, where the learned judge said that it may be that some of the disclosure that ought to have been given by Telefonica will in fact have been given by Vodafone or O2, because they gave more appropriate disclosure and retained more documents. 2 points on that, if I may. One just on the facts. Firstly, it's obviously right that that would be true for some documents. Assuming O2 and Vodafone had appropriate preservation measures, some documents that would have been covered by proper disclosure from Telefonica will have been disclosed by those parties. But as we say in the skeleton argument, the evidence at trial showed how very important and telling internal documents could be in revealing the fruits or fact of collusive contact. So if I may just give briefly 3 examples. The evidence relating to the landmark lunch comes almost exclusively from documents internal to EE or O2. You give the example of Mr Evans' text message to Mr Dunn. That's the text message that referred to Mr Dunn perhaps wanting to reassure Mr Swanty to strengthen the operator's resolves. That's referred to in judgment paragraph 198C. Second example, the evidence in relation to the drill down workshop on the 7th of May 2014, the EE workshop. That came from notes made by Mr Deloison of Orange in an email that he sent to Mr Nolo, also of Orange. And the email, finally, the email at the very heart of ground 3, referring to an expectation that Voda were about to pull out, was sent by Mrs Derbyshire of EE to Mr Eyre. So an email internal to EE, and in fact internal to persons that we did not say had any collusive knowledge, nonetheless shed real light on information that we say EE obtained through collusion. So those kind of internal documents are key. Second point, crucially, if the learned judge erred in law in his approach to whether the document destruction was deliberate, as we respectively submit he did, his decision on what inference to draw cannot be saved by the fact that he also took into account that some documents lost or destroyed by Telefonica might have been retained by other parties. One can see that that factor might have weight in the case of innocent destruction, which is the basis on which the learned judge proceeded, but it's very different if the destruction was deliberate.
Sorry, just where does this take you? Because the judge was clearly aware that a decision had been taken not to preserve emails. Yes, he may have made the reference to innocent.
Yes.
But where does that get you in terms of your characterisation?
Well,
Are you saying he wasn't entitled not to draw an adverse inference?
Indeed, because we're no longer in a position where he was correctly directing himself as to the relevant legal principles and simply took a view. That's what a phobia tells you. In the ordinary case, where the judge simply takes a view and weighs all relevant circumstances, it will be very hard to challenge a decision taken.
Well, your point is this, isn't it? Putting it simply, the judge was wrong to say that the destruction was innocent as opposed to deliberate.
Yes.
And therefore that infects his conclusion that it wasn't appropriate to draw an adverse inference.
Yes, it's an error of approach or law as
Yeah.
opposed to his weighing of the relevant factors. Another way to look at it is that he got it wrong on a crucial factor. So effectively, if one did it by reference to relevant and irrelevant considerations, a key relevant consideration to which he had to have regard was that this was deliberate destruction.
Yeah. Okay.
The last point arose from a discussion around examples of the learned judge allowing Telefonica to rely on the absence of documents, so positively relying on it in order to defeat an allegation. And the example we gave was judgment paragraph 138. 2 points on that. Obviously, the learned judge is unlikely to identify every instance in which the absence of relevant documents that Telefonica may have disclosed played a part in his reasons. So the fact that it doesn't appear in many paragraphs of the judgment doesn't tell you that it didn't play an important role. And as I've been submitting, second and final point, the learned judge did not even expressly consider whether he ought to, as we invited him to, effectively preclude Telefonica from taking that approach in light of his conduct. In any event, if he had done, he would have had to take firmly into account that, as I've said, the document destruction was deliberate. Those are my submissions in reply.
Thank you very much. Yes.
May it please the court, I'm going to address, first of all, the issues of law and then follow up with the other grounds, 3, 4 and 5. Now, as an introduction to the issues of law, it's important, in my respectful submission, to bear in mind what our case is in terms of the nature of the infringement. And our case is that this is a by-object infringement. We don't have, if it's a by-object infringement, it's not necessary to show that the infringement actually had effects in the market. And the learned judge, you'll recollect, when it comes to deal with the question of causation, notes specifically that this was a by-object infringement. That's my first point. Now, my second point is this. In the light of the facts as found by the learned judge, specifically in paragraphs 197 through to 199, that, as a matter of law, established a by-object infringement. And my learned friend, Mr Bailey from the CMA, came along and made that precise point. Wasn't challenging the findings of the learned judge, that was simply saying, as a matter of law, on the basis of those findings, that constitutes an object infringement. And we agree with that, and that has been our submissions throughout in any event, as set out in our skeleton argument. Now, ground 1, issue 1A, was the approach too vague, even if accepted? Mr Hoskins dealt with that yesterday, and he argued valiantly that the judgment should be read to the effect that even Swanty had taken up Mr Dunn's invitation to collude, there nonetheless would have been no consultation. For that to be right in our submission, Mr Dunn would have had to fail to get across the thrust of his anti-competitive approach. But as my Lord the Chancellor observed, the learned judge plainly found that the thrust of the anti-competitive approach had been understood, judgment paragraph 197. And we know that Mr Swanty understood Mr Dunn to have been indicating that O2 was contemplating pulling volume from the indirects. And that's what the quotation from Mr Blendis's email at judgment 158 establishes. It is true, as the learned judge noted, that Mr Dunn did not specify whether the big card he had in mind was pulling volume from Phones for You or Carphone Warehouse or both. But he did not need to do so in order to sound out EE as to strategic cooperation against the indirect retailers. And as one will see from another document that the judge didn't take into account in this particular, when we get to ground 4, I think it is, there's a question whether the indirects had a shared resolve. Forgive me, whether the MNOs had a shared resolve against the indirects. And we are going to submit, when we come to look at the relevant document, you'll recollect it's the Evans chat, that shows that there was, to an extent, a resolve against the indirects, which we will submit, had been generated by illicit means. Now, that brings me then, my Lord, to the point about specificity, which my learned friend, Mr Hoskins, dealt with. And if I may respectfully say so, my Lord Justice Phillips put his finger on the point. The true principle is identified in the Portuguese bank case. There isn't some generally applicable threshold of specificity for information sharing which contravenes the strict prohibition. All the cases establish that sometimes information which is shared between competitors may be confidential but not strategic in the relevant sense, and our lack of specificity may be one reason for that. May I invite the court to turn to page 3282 of the authorities bundle and see the definition of strategic information, which is in paragraph 63. You see there, confidential information must be understood as information not already known to any economic operator active on the market concerned, while strategic information must be understood as information that may reveal in some circumstances, once combined with other information already known to the participants in an information exchange, the strategy which some of those participants intend to implement with regard to what constitutes one or more parameters in the light of which competition on the market is established. So, strategic information in this case was covered by the phrase playing big cards. It was understood by Mr Dunn. By Mr Swanty, what that meant. And he accepted it. Mr Hoskins, of course, stressed that Mr Dunn did not say O2 was in fact going to play its big cards. But there are two problems with the idea that a lack of settled decision prevented his approach from being an effective invitation to collude. First, if we may remind ourselves in the authorities bundle from the Soka Unia case, page 1934 of the bundle, we see at paragraph 174, it's correct to say that the requirement of independence does not deprive economic operators of the right to adapt themselves intelligently to the existing anticipated conduct of the competitors. It does, however, strictly preclude any direct or indirect contact between such operators, the object or effect of which is either to influence the conduct in the market of an actual or potential competitor, or to disclose to such competitor the course of conduct which they themselves have decided to adopt or contemplate adopting on the market. What the principle of independence, which underlies Article 101 on the domestic analogue, does not allow competitors to road test strategic information by sitting down at a meeting with their competitors and seeing what reaction they get to that. That's impermissible. For example, if Mr Dunn, for whatever reason, had been less guarded, and he simply said to Mr Swanty in the meeting, we've taken a provisional decision to exit from Phones for You, and we're going to do it next week. If he'd said that, and that had not been rejected at the meeting, that would amount to consultation. One of the first element in the concerted practice. But the fact that he expressed himself in more guarded terms doesn't alter the fact that this was consultation when the approach was made, information which was understood was conveyed and not rejected.
I think one of the points that was made, I'd just like to know your answer to this,
yes.
is that this wasn't information so much as it was a conditional reference. You're saying, what the judge says at 197 is that what was proposed was if O2 reduced its reliance, if E might. So it's not conveying any information at all, it's making effectively a proposal.
Well, a proposal, in my submission, necessarily conveys information. Necessarily. It necessarily conveys information as to what is in the contemplation of the party making the invitation.
But isn't it no more than this? We're contemplating pulling out of one or more of the indirects.
Yes.
And we want to know what your reaction is and whether you'll do something that wouldn't be in our best interest. And that's the sort of overall message.
Yes, it is. And that is precisely what is regarded in the case law as sounding out. And sounding out is an anathema to the rules of competition. As we see, we've still got it on the screen. Paragraph 173 in Sauka Unya, the criteria of coordination and cooperation laid down in the case law must be understood in the light of the concept inherent in the provisions of the treaty relating to competition, that each economic operator must determine independently the policy which he intends to adopt in the common market. So, from the very start, what Mr Dunn was about, they've got a provisional decision on the 12th of September. They recognise that that provisional decision exposes them to risk, not least because of what happened in the past. The internal documents show that they recognise that this was a risky decision. So what happens is that Mr Dunn goes along, sits down with Swanty, and in the course of this one-to-one meeting between competitors, starts talking about price fixing. Now, price fixing is at the ultimate limit of bad behaviour. So he's trying to engage Swanty in price fixing in relation to the 4G service, which EE have stolen a march on the other competitors. What Swanty ought to have done then is show the red card. I'm sorry, Mr Dunn, I want nothing more to do with what you're saying. But no. Mr Dunn went to use the facilities apparently, and when he came back, Mr Swanty had set his iPad to record in anticipation that other things might be said. And other things were said. And that's the playing of the big card, etc., etc. Yes, if we look at perhaps judgment 180, please. 313. Yes. This is the the Blendis speaking note, which we prepared for his approach to Vodafone and O2, and where he rather didn't protest because he'd been told by Swanty to be a super diplomat. But in any event, indications of intentions to encourage certain collaborative behaviours included references to actions by O2 that would otherwise be highly sensitive and confidential to the O2 business and could only have been made to influence decisions by EE to support such actions. For example, with reference to value in the distribution space, O2 was indicated to be willing to play some big cards.
I know this goes on to, this is really more relevant to ground 4, but
yes.
This only makes sense from Mr Dunn's perspective. He also is going to raise this with Vodafone.
No, absolutely. Entirely.
Otherwise there's no point.
No, indeed. And our case, obviously, at trial was that he did. The judge rejected that on the basis that it was speculative, but in so doing so, he ignored the only documents which we put to the court to show that it wasn't just inherent probabilities, there were actually documents which supported that proposition. And I'm going to take you, my lord, to the Evans text message.
I don't want to take you out of your course.
No. Yes, your lordship's right. The whole point of Dunn's approach was to de-risk this provisional decision. And as I said, sounding out a competitor on the market is a paradigm example of an object infringement of the kind identified in Sauka Unya and Nichikon. I'm not going to take you back to the Nichikon case, which I showed the court on Monday, but that's, I do invite the court in due course to reread Nichikon, tab 54, pages 3120 to 3121 in the bundle. Now, that's the first point. As regards question 1b, passive responses, that was Mr Pickford who did the running. But in doing so, he built a straw man of our case. Much of his submissions were directed to rebutting an argument that an anti-competitive approach per se gives rise to consultation subject only to public distancing on the part of the recipient of the approach. But that is not our case. As you'll recollect on Monday, I said there were 3 ways in which Mr Swanty could have responded. Red light, that's a negative response, rebutting the approach or rejecting the anti-competitive disclosure. That would not give rise to the first element of concerted practice, consultation. That's not because a negative response is public distancing, but because whether an approach is rebuffed or rejected, the disclosure will not have either been requested or accepted. See the Simonteri's case. Now, my Lord the Chancellor put his finger on, if I may respectfully say so, when he asked, what does accept mean? Yeah. In our submission, in the context of an anti-competitive approach or disclosure with the object of distorting competition, the approach or disclosure is accepted when it is not rejected. And you may recollect that I used the concept of non-opposition or the absence of a red light. And I also mentioned in this context the decision of the CAT in JGB Sports, referring to the importance of treating a passive response as providing positive support for the purposes of enforcement of the relevant provisions of the Act. Ultimately, in our submission, what constitutes acceptance is ultimately a matter of legal policy. And legal policy in this case requires the court to hold that if you do not reject, but passively accept an approach such as that performed by Dunn, that will give rise to consultation. Now, Mr Pickford said, well, we've got a gotcha point, and that's because you accept that in not all circumstances, passivity will give rise to consultation. And the case which has cited against us, in which the judge referred to, is the case of Aturus. Aturus, on the facts, is nothing like our case. that was a case where a message which popped into an inbox may or may not have been read by the recipient. And the absence of a response to the receipt of an email couldn't be read as non-opposition or acceptance. It may convey nothing more than the fact that the message was either not received or understood. And in our submission, that is why the CJEU in Etura spoke so heavily, as we see in the judgment of the court, as to whether the recipient was actually aware of the message. But that's nothing to do with how the law treats a situation where one competitor's chief executive officer sits across the table from another chief executive officer and makes a collusive proposal which is not rejected, walks away, knowing that his proposal has met no opposition and not a total lack of interest. In that situation, the active colluder knows that both the proposal itself and the idea of collusion have not met with the opposition that they should have. It provides a measure of comfort as to the likely reaction of the competitor should the contemplated strategy be deployed on the market. So what that then leads to is this. My learned friends trying to reinterpret paragraph 225 of the learned judge's judgment. One suggestion was that where it refers to Mr. Swanty not being wholly uninterested and not clearly opposed, they were talking about a general impression. The judge was talking about his general, the impression as to general attitude towards collusion, rather than what was communicated back to Dunn as regards specific collusive approach that was made in relation to indirect retailers. But in our submission, that's incompatible with the final sentence of Judgment 225, page, we need to start at 326.
Sorry, where are we now?
We are in paragraph 225, my lord, the last sentence of the judgment in 225. It would also be inconsistent with Evans' text message to Dunn, suggesting that they should reassure Swampy, and this is the important words, as part of strengthening the resolve against the indirects. Now, Mr. Evans' text message therefore assumes that there was some degree of resolve to strengthen. And it shows that the paragraph, which in paragraph 225, that the learned judge is referring...
When he's talking about that he wasn't objecting or wholly uninterested, that was in the context of a move against the indirect.
Correct, precisely.
Otherwise the judge wouldn't bother putting in that last sentence.
That's exactly our submission, my lord. That also is the only conclusion which fits with the way in which the learned judge in his permission judgment treated paragraph 225 of his judgment, and perhaps we ought to look at that again. Core bundle 19, paragraph 22. And it's page 469. And if I could ask the court to read that again to themselves. Now, the whole premise in my submission with this paragraph is that the learned judge is squaring paragraph 217 of the judgment with paragraph 225 on the basis they are both addressing Mr. Swanty's response to Dunn's approach and what Mr. Dunn would have taken from Swanty's passivity. The learned judge does certainly not say, oh well, paragraph 225 is actually dealing with what Dunn would have taken as regards as regards collusion in general without reference to the specifics, as my Lord the Chancellor put in relation to indirects. Now, Mr. Pickford suggested, I think, that the judge does not, in the final sentence of this permission paragraph, provide any clarification as to what the legal test was that he was applying in 217. But in my submission, that is precisely what the judge was doing here. He is explaining why the findings in 225 do not undermine his conclusion in 217 that there was no consultation. And he squares those two paragraphs by explaining that the findings in 225 were insufficient to meet the legal test that is set out in 217, namely a requirement for positive support or an implicit agreement to cooperate. And we simply say that test that the judge clarifies in paragraph 22 is wrong in law. Passive response qualifies to give rise to consultation. It doesn't need to be sorted into one of two categories of infringing and non-infringing passivity. As a matter of legal policy, if we are to be serious about the enforcement of Article 101 and the domestic analogue, it depends is not the answer. And as the Nishikon case shows, any response which distorts the conditions of competition, which gives the would-be colluder something he would not otherwise obtain, qualifies. A guarded approach met by non-opposition is enough. Dunn knew that he'd got his point across to Swanty, and he knew that Swanty had met that with non-opposition. And that was information which he should not have had as a competitor acting independently on the market as Article 101 required him to do. Now, that brings me to the question as to whether there is any relevance to what was actually in Mr. Swanty's head and whether they were, in some sense, ad idem. A learned friend suggested yesterday that there was indeed such a requirement to show that the parties were, in some sense, ad idem, and that language came from this court in the case of Argos. And we can see, go to the judgment, paragraph 77, page 280. And please scroll down to 4. I think we looked at 4 yesterday. A decision on the part of a manufacturer which constitutes unilateral conduct of that undertaking escapes the Chapter 1 prohibition. Then this, the concept of an agreement centres around the existence of a concurrence of wills between at least two parties, the form in which it is manifested to be unimportant, so long as it constitutes the facial expression of the party's intention. So that is the law about an agreement, but the law on concerted practices is set out in paragraph 5. And it says this: although the concept of a concerted practice implies the existence of reciprocal contacts, the requirement may be met when one competitor discloses its future intentions or conduct on the market to another, and when the latter requests it, or at the very least accepts it. Semantic. In other words, in our submission, there is a clear line of authority in relation to passive participation in a concerted practice. And acceptance of anti-competitive disclosures requires my learned friends to stray from that authority to try to support a requirement to show positive support on the facts. Ground 2, if I may. The debate on subground 1, whether the Anic presumption applies to all participants, has essentially collapsed into a debate under ground 1. If phones for you are right, that a passive response is treated as conveying non-opposition back to the party that makes an anti-competitive approach or disclosure, then there is information on which the Anic presumption can bite. If there was information flowing back to Mr. Dunn, my friends seemingly accept that the Anic presumption would apply to that information in O2's hands. So if we're right about what we say under ground 1, this doesn't present an additional obstacle. Ground 2.2, the means of rebutting the Anic presumption. In our submission, this turns on the interpretation of the case of Achurus. Learned friend Mr Pickford spent some time arguing that it would be absurd for there to be a strict rule for cases involving anti-competitive meetings and a more permissive approach for those which did not. What about video calls, for example, he suggests. But the problem with his rhetorical flourish is that irrespective of which of us is right in relation to the interpretation of Achurus, that case plainly does draw a line in our submission between cases involving meetings and those which do not. The distinction is plain in terms of paragraph 46 of that judgment. Now, I would agree with my learned friend that if the submission was that the CJEU might well treat a video call as being in substance the same as a meeting, so the strict rule should also apply to video calls, they might well do so. But we don't need to worry about cases, more difficult cases at the edge, because here we have the classic anti-competitive meeting between two chief executives of competing undertakings, the kind of circumstance to which, in our submission, the general rule requiring public distancing plainly applies. Now, the question of whether paragraph 46 of the court's judgment in Achurus, whether that's dealing with a different presumption from the presumption referred to in Article 49, is, we say with great respect, clear. There is only one tenable construction of paragraphs 46 to 49.
Should we just have those on screen?
I'm going to take the court to the Sainsbury's case first, if I may.
Okay.
And if we could have up tab 24, pages 1187, and scroll down to paragraph 100. Can I invite the court to refamiliarise itself with paragraphs 111 to 114? Now, my first submission is that the reasoning in these paragraphs is clearly not obiter and can't be brushed aside as a slip which is made by their lordships in the Supreme Court. Achurus was relied upon by both MasterCard and Visa on a key legal issue on appeal, namely whether EU law could dictate or mandate the nature of the evidence which could be required to satisfy the requirement of Article 101, in that case, Article 101.3. The Commission, as the Court will see, also made submissions on the interpretation of Achurus. The key paragraph for these purposes is 113. And the Court will see that the Supreme Court says, they refer first of all to paragraph 33, and they say the Court of Justice went on to distinguish the presumption arising in Article 101 of a causal connection between a consultation and the market conduct of the undertakings participating in the practice. That presumption, it emphasised, followed from Article 101 and consequently formed an integral part of the EU law, which the National Court was required to apply. The Court of Justice then went on to address in detail the nature of the evidence which would be sufficient to rebut the presumption. Now, address in detail is the important point there. We then turn to the Achurus case, and that is at Authorities tab 51, page 3005. Now, we see Paragraph 46, if we can have that up, please. Now, what we say about this is that paragraph 46 identifies that in a case such as a Turris, there are two options, public distancing and other evidence, in order to rebut the Anic presumption. Paragraph 49 addresses the other means of rebutting it. So you've got public distancing in the circumstances of that particular case, not necessarily so easy. Yes, that's in 47 and 48. And 49 is dealing with the how you distance from the situation with which they were faced. Now, my learned friend's submissions were that paragraph 46, if we go back, was dealing with the presumption which established consultation only, but that is not what it says. It refers in the first sentence, it may rebut the presumption that it participated in, not a consultation, a concerted practice, by proving it publicly distanced itself from that practice, i.e. a concerted practice, or reported it to the administrative authorities. In addition, according to the case law of the court, in such a case as that at issue in the main proceedings, which does not concern an anti-competitive meeting, public distancing or reporting are not the only means of rebutting the presumption that a company has participated in an infringement. Now, the words of the phrase concerted practice and infringement are used interchangeably because they mean one and the same. A concerted practice requires three elements: consultation, conduct on the market, and a relationship of cause and effect between the consultation and the conduct on the market. It requires all three elements to be established. As I say, it's made perfectly clear in paragraph 46 by participation in an infringement. Simply establishing participation in consultation does not, without more, establish an infringement. Then if we look at paragraph 49, that paragraph begins by referring to rebutting the presumption of participation in a concerted practice. The same thing as was being referred to in paragraph 46. Same concept. My learned friend has no answer to this other than to argue that the CJEU was expressing itself unclearly. It did not express itself unclearly, nor did the Supreme Court, when it referred to the presumption, misspeak or misstate itself. Finally, if one looks at paragraph 50 in relation to the answer which is given to the referred question, you'll see that the CJEU refers to that presumption. It's only talking about the single presumption, namely the Anic presumption.
Where are you referring to then?
Forgive me, my lady. It is in line second. Penultimate line.
Oh.
Of the first indent, reported to the administrative authorities such as other evidence to rebut that presumption. What ladyship see that?
Sorry, you think that's all relating to the Anic presumption?
Yes, that presumption.
So where are you reading from there? I don't know if I follow.
Right, we start at Article 101 under the indent in 50.
Yeah. Must be
and
interpreted as meaning, yes.
read down, and you get to be presumed to have participated in a concerted practice of the meaning of that provision unless they publicly distance themselves from that practice. Concerted practice, not consultation, concerted practice. And it talks about the evidence of rebutting that presumption, i.e. the presumption, the Anic presumption of participation in a concerted practice, which requires there to have been prior consultation, conduct on the market, and relationship of cause and effect supplied by the Anic presumption.
The difficulty with it is though that apart from this detailed analysis, it just doesn't seem to make sense to me, because if you're talking about a rebuttal of the presumption of causation, public distancing has got nothing to do with it.
Well, I mean, the strange thing about this is it appears to be accepted if paragraph 46 is talking about consultation, it's accepted that public distancing is effective in relation to that.
You can understand this in the context of the first stage of whether there's consultation, because if Mr. Swanty's reaction to Mr. Dunn's approach had been to stand up, walk out of the restaurant saying, I'm having nothing to do with this, gone straight back, spoken with Mr. Brandis, and they then telephoned the CMA, that would be the most obvious example of public distancing. And clearly then, it couldn't be said there was consultation. But as to whether or not there's causation, I find it much more difficult to say, well, it has to be public distancing, because there are also, as Mr. Pickford pointed out, there are all sorts of other things that could mean that that even if there was consultation, it wasn't causative, such as Mr. Swanty dropped dead as he walked out after they'd had a collusive chat.
That's a different point.
Yeah.
If I may respectfully say so, my lord, if Mr. Swanty at the lunch had stood up and said, I'm leaving, I don't want to hear any more about this, there wouldn't be consultation in the first place. That's
a red light.
That's a red light.
A red light.
That is a non-acceptance.
Yeah.
It's a rejection.
Yeah.
If it had been positively embraced, my respectful submission, one could not doubt that there was consultation. If Mr. Swanty had said, I think this is a fantastic idea, we're right behind you, consultation. Our point is that, as a matter of law, passive response to an approach such as we see took place at the lunch gives rise, necessarily, to a concerted practice. That's when the Anic presumption then comes in, which presumes that if there's continuing conduct in the market, as there plainly was, and there's no dispute about that, in relation to both these entities, then there was consultation. Now, we're not yet at the stage, well, if there's consultation, the only way, in my submission, to get out of that is by public distancing, and that's what a churus establishes. Different question, whether if there has been an infringement, a concerted practice, which has not been rebutted, whether as a matter of domestic law, and we're going to get to that bit, whether as a matter of domestic law there is causation. That's a domestic law question.
Okay.
Now, we say that there are simple rules in this regard. First rule is don't soak up passively anti-competitive approaches and information. Two, if you have, make sure you publicly distance.
So, sorry, just to understand this, going back to my example, if Mr. Swanty, okay, this is not passive acceptance, but it's the second example of where he says there's a discussion, and Mr. Swanty says, well, that sounds like a good idea. I'll see what my people think about it, and then drops dead as he walks out.
Yes.
That you would say, would you? There was an infringement. All three elements are satisfied, but there's no causation as a matter of English law, or what? It seems to be the logical consequence of the submission you're making.
Well, respect no, my lord, because concerted practices are performed by undertakings, not by individuals. Individuals don't have liability under the
No, I follow that.
Under the Act. So, it's always possible.
The CEO has authority. You can't. That's not an answer.
No.
The CEO has authority.
Well,
he said it's a good idea. He's there representing.
Yeah.
EE.
Yeah, but there wouldn't. It has to have some. You have to look at this. Every legal rule is potentially challenging on the basis of a reductio ad absurdum. In our submission, this is an absurdity. Mr. Swanty did not drop dead. Mr. Swanty went back to EE, and he recognised that he had got himself into hot water. But for his own commercial reasons, he decided to do nothing about it. And that, one, gave rise to consultation, and two, because he did not publicly distance, there is an infringement. It's a paradigmatic case in our situation. Now, if
I suppose you would say, would you assume for the purposes of the argument that you've got stage one is established, that there is consultation.
Yes.
And you're looking at stage three, cause and effect.
Yeah.
Absent public distancing, there being no public distancing, there's nothing else that's suggested that would amount to sufficient refutation of the causative effect. I mean, that's the point you're making.
Yeah, that's the point I'm making. The learned judge, the argument, one of the arguments was run by my learned friends at trial was that there had been sufficient public distancing, either by body language or some other means. And the learned judge rejected that. So, if we're right, there was an infringement, there was no public distancing. So, we then move further on to what the consequences of that are. Now, we say in the alternative, if we're wrong about public distancing, they would have had to satisfy the burdensome test in the Solvay case, which the court has seen. My learned friend Mr Pickford fairly pointed out that in the Solvay case there were various items of anti-competitive behaviour. But what he didn't take issue with, as I understand it, was that the Solvay case set out the relevant test as to what is required to rule out any link whatsoever between the concerted practice, the infringement, consultation and subsequent conduct. He didn't dispute that. And that's a burden which was on EE as the party who had to rebut presumption. It wasn't acknowledged at trial to that effect by EE, and doesn't feature in the learned judge's judgment. The Solvay case is just not referred to. Right. I've got quite a bit to get through this afternoon. Yeah. And I move briefly to the question of causation under domestic law. There is largely no dispute between the parties on this. We agree that an object of infringement, such as we have in this case, does not establish loss and whether an infringement had any causative influence on O2's exit, which is a matter of domestic law. But our point, which is largely overlooked in all the common ground, that on the judge's analysis of causation, it cannot proceed on a basis which is inconsistent with what the presumption has established this far. It can't be inconsistent with the infringement as found. And no effort was made to suggest that the learned judge's analysis of causation was consistent with the infringement that he should have been assuming for the purposes of this stage of the analysis, or that the judge accepted, pursuant to the Anic presumption, that the consultation had an effect on the mind of the relevant decision makers before going on to apply common law causation analysis. And in our submission, that cannot be right. To proceed on a causation analysis which is inconsistent with effectively the facts as found by the presumption. That's all I want to say about the law, if I may, and move on now to the other issues. A couple of general points to make. My learned friend sought to persuade the court that even if it was persuaded that the judgment was in some way unsafe in a material respect, the court should consider in the round whether it would be in the interests of justice to order a retrial. They referred to the delay, the cost, and the prejudice to them as successful defendants. But as I submitted in opening, where a judgment is unsafe in a material respect, the court has no option other than to take the unpalatable course of ordering an appropriately limited retrial. In our submission, that is the only course which is compatible with this jurisdiction's approach to the justice of the matter. And I wonder if we could have up on the screen the NatWest and Bilter case, please, to see how this court dealt with that on that occasion. And that is at page 1273 of the authorities bundle, paragraph 122. And I wonder if I could just, in the interest of time, invite the court to refresh the court's memory about that's what I said there. Now, court in our submission, if the court comes to the conclusion that the judgment is unsafe in a material respect, should steel itself to resist the siren song coming from the other side of the court. However attractively put, you should decline to order a retrial of whatever nature on the grounds of cost, delay, or inconvenience. And that also holds true for a long and detailed judgment into which, and obviously, a great deal of work has gone. Now, as far as the scope of any retrial is concerned, I address, my Lord the Chancellor and the Court on what that might look like. In our submission, the position is this. It would take its scope, or lead, from the specific respects in which the judgment had been found to be unsafe. And as this Court is well familiar now, the way in which this case it involves distinct episodes and sub-episodes which are related in various ways. But it will to be expected that any retrial would take as its starting point a particular episode or sub-episodes in respect of which the judgment has been shown to be affected by some error under one or more of the grounds. Now, take ground 3 as an example. This ground could give rise to, at least as a starting point, a limited factual inquiry into by whom and when the information about Voda being expected to exit was conveyed, other than the obvious source, Vodafone. How a first instance judge would approach that, and at what stage, if any, they may decide that a broader factual inquiry was required, would obviously be a matter for them. And as I already submitted, and as this court held in the St. Petersburg case, this court wouldn't wish to tie the hands in that respect of a fact-finding judge. We actually contend that any retrial would of necessity be broad because of the number of episodes on which we rely, where the judgment is unsafe by reasons of ground 3, 4, 5, and 7. But the extent of our success on those points could obviously fall within a spectrum. And every point on the spectrum would have a different implication for the scope of such a trial. Now, before I come to in detail of the grounds, there's a general point that my learned friends have made references to what is or is not in the judgment. And unfortunately, a number of instances in which this court was given an inaccurate summary of what the judgment says. Includes statements as to whether evidence was in fact referred to, and statements as to the nature of the judge's findings on particular points. But one theme which runs through all of it is that this court should be slow to conclude that a particular aspect of the judge's conclusion is unsafe, because there are many other findings, other pieces of evidence. My learned friend Ms. Demetriou referred to island hopping, but in our submission that turns the proper approach on its head. If the judgment is unsafe in a particular respect, the burden would be on my learned friends to demonstrate that that error can somehow be quarantined in a case of this nature, such that the court can be satisfied that there is no infection of the judge's overall conclusions. It's not right simply to put a lot of other findings said to be unchallenged as though they were reached through a distinct fact-finding process which can somehow be isolated and treated as cast in stone and immune to any finding which this court concludes is unsafe. Take the example of the Our Intel email. A learned friends seek to persuade this court that even if, contrary to the judge's findings, there had, as is suggested by that email, been a discussion between Ms. Castillo and Mr. Hum that touched on forward-looking strategic information, this court should save the judgment by concluding that any infringement necessarily had no causal effects. In our submission, the court should resist the temptation to retry aspects of the case by trying to infer how a piece of evidence might be dealt with without knowing what all the other evidence was and how it was challenged and how the different pieces of evidence interrelate. Now, in theory...
Isn't that why it would be very difficult to have a limited retrial?
Yes. Often it would. Often would be the case. It may be that, for example, let's take the example of the Dunn-Lawrence, the alleged Dunn-Lawrence collusion. The court might take the view that if the inherent probabilities which are pushed over the hill, over the hurdle by the evidence which the judge didn't refer to, that you might start with a limited retrial there. I can well see the difficulties to which that would then give rise as to what further effects that might be. But in our submission...
I think the point my lord's making, in a sense, and it's a point that I made at various stages.
Yes.
True it is, some of these points can be viewed in isolation.
Yes.
The truth is that, in a very real sense, they all tie together.
Particularly, your lordship's right, particularly in relation to the nature of the allegations in this case. Allegations.
Well, I mean, in a sense, yes, it's true. There are two or three distinct periods of time.
Yes.
But in each of those periods of time, there are a whole series of things that are going on.
There are.
I mean, the Landmark Hotel incident impacts on the Dunn-Lawrence incident. All the stuff in 2014 is all tied in with. They're all tied in together, I think.
Yes.
Well, the witnesses are the same, for one thing.
Yeah. Forgive me, Mark.
The witnesses are the same. So if they are recalled, they'll inevitably have...
The witnesses are the same. Many of them. I can't say they're all the same. For example...
You couldn't limit the cross-examination on a retrial to just specific incidents, because things may be said that reflect on other incidents.
Indeed. I see that, but again...
I don't see how you could in any way put things into silos.
No.
And the judge would rely upon findings by the judge in this case and overlay them with his findings on the evidence in a retrial.
I do not shrink from the fact that it would be difficult. I don't. But ultimately, if the court were persuaded that this judgment was unsafe, it can give indications, as the Chancellor then was in St. Petersburg.
Well, paragraph 122 says it.
Yes.
It's unpalatable.
It is.
That's what fairness requires.
Absolutely. And
that's what happened.
I personally, I don't want to go through the exercise again, but my personal feelings are utterly irrelevant.
Right.
And now, ground 3. There are two questions in relation to ground 3. Was the judge permitted to adopt his car phone warehouse theory, not having been raised by anyone in evidence or submissions, and has phones for you been harmed or prejudiced by the judge's adoption of that theory? Question 1. The only real attempted defence of the judge's approach was that there was a pleading dispute as to whether Vodafone had passed this information on to EE. So the judge had to decide that disputed question, but that by itself gets my learned friends nowhere. The judge did indeed have to decide the pleaded question as to whether Vodafone passed that information to EE. But in answering that question, the judge, respectfully, had to confine himself to the factual theories, to the evidence and submissions advanced by the parties. He couldn't rely on a new factual theory if the parties had not had a fair opportunity to interrogate that particular theory. If there were questions the parties might have wanted to ask, disclosure they might have wanted to seek, submissions they might have wanted to make, the judge, in our respectful submission, cannot deprive them of that opportunity by putting forward a theory of the facts for the first time in his judgment. And the prejudice doesn't derive or depend on the fact as to whether this is a pleading point, or relates in more general sense to the cases the parties advance. The pleadings, obviously, are an important document and shed light on what the parties' cases at trial were. But this CPW theory, as the court knows, was nobody's case at trial, not the subject of evidence or argument. In my submission, this new theory was impermissible as a matter of law. Now, the real thrust of the defence submissions is that that Claimant has not been prejudiced by what the judge went off and did. And so they say this new theory of the judges didn't make any difference. First, it didn't make any difference in relation to his conclusions in this email. And second, if it did affect his conclusions in respect to the email, still wouldn't have made a difference to the judge's overall conclusions. But I make one general observation. However, the defendants want to put their argument that the adoption of the new theory made no difference, it runs headlong into the same basic problem. And that, with respect, is the point put to me by my Lord the Chancellor a few days ago. There is obvious prejudice because we just cannot know what would have happened had the theory been raised and had there been an opportunity to explore it. We don't know what Mr Milson would have said about it. We don't know where any train of inquiry might have led. As my Lord noted, in a case like this, there are pieces of a jigsaw. Once you look again at one finding, other findings are potentially also looked at through a different prism, to mix my metaphors. The court is not being asked, and cannot be asked, to assess on some sort of probability scale how likely it is that a different analysis of one piece of evidence would have had led to a reconsideration of some other piece of evidence. The whole point of insisting that in our adversarial system, judges do not originate their own theories of the facts to prevent this sort of issue arising. It might be tempting to consider whether the judge might, by some other route, have reached a materially similar conclusion. He could, for example, have accepted EE's case that the source of the expectation was simply market rumour, but the learned judge did not accept that case. And in our submission, we are entitled to the conclusion that the judge would have reached if he'd been foreclosed from adopting this theory. Equally, another judge might...
Sorry, do you say you're entitled to the conclusion that the source was Vodafone?
Yes. There were two plausible options. One, that it came from Vodafone, and that was the obvious inference, and the judge recognised that that was a plausible, obvious inference. The inference which he found to be more plausible was his own theory. And as the court will see, he said, is there another realistic possibility? And the other realistic possibility was the car phone warehouse theory. And if that is foreclosed...
Let's just have a look at that again.
Give me, my lord.
Let's just have a look at the paragraph.
Of course. Yeah. We're looking at paragraph 602. Yes. And 605, my lord, where you see the reference to the phrase no other realistic possibility. No. As my Lord Justice Phillips observed during the course of argument, that there was a strong default that Vodafone's confidential information came from Vodafone. And if the judge were to reject that strong default position, they would have to give a reason for doing so. And the royal judge did. And his reason was the impermissible car phone wear theory. Now, in submissions, Mr. Williams suggested that even if the possibility that the information came from car phone had been entirely disregarded, the judge would not still have concluded the information didn't come from Vodafone. But that's impossible to square with the structure of the judgment. We see how the point comes through in paragraph 605. The judge says he's not making a positive finding, this theory is correct. And then halfway down the paragraph, 3 words in from the right, he says that in dressing whether on a balance of probabilities, the email shows an information exchanged in EE Vodafone is relevant and appropriate to consider whether there is, quote, another realistic possibility. So it was a necessary step in the judge's analysis of what this showed on the balance of probabilities. And he identifies the car phone theory as the only other realistic possibility. No third candidate.
He says he doesn't make a finding, but he's effectively found it, and the balance of probabilities is a car phone warehouse.
Correct. And that's as good as making a finding. So he says, I'm not making a finding. It is determinative. It's obviously determinative. Yes, he might have thought that without car phone warehouse being there, he might not be in
I
a
never
position
understood
to
that
reach
bit
it.
of the judgment, because if you decide on a balance of probability it's car phone warehouse, then you're making a positive finding.
Yeah.
It's a matter of English law, English civil law.
Yeah. Now, Mr. Williams said a number of times that the theory caused no prejudice, but that submission simply doesn't get off the ground. He said that the judge made a finding that regardless of where the information came from, it was transmitted in August, which was too late to have any causal effect. But he made no such finding. If you look at paragraph 602, about halfway down the paragraph, he says, as is apparent from this email, by the end of the first week in August, there was at least some expectation. So the only thing to tie in the timing was by this period in August. He made no finding that it came in August. Now, another point which was made by Mr. Williams, and I think again by Mr. Pickford, looking at the words at the top of the page, 428, paragraph 599, these words, he wants to be 100% sure of the impact of phones for you falls earlier than expected, i.e. in the next couple of months. Now, the judge does not say in his judgment that the earlier than expected wording compelled the conclusion that the email was sent in August, or that the information was acquired in August. The natural meaning of these words that Milsom, who you'll recollect we say was in the circle of collusion, had told Mrs. Derbyshire, who we did not allege was, and by extension Mr. Eyre, the plans for you folding earlier than they had expected. So an imminent collapse and exit would be earlier than they expected.
So they being those not involved in the collusion?
Correct. In any event, the judge didn't make any findings about this, and so it can't. This point can't save. If you're with me that this car phone warehouse theory was impermissible, that argument can't save the position, because it's a matter which is going to have to be investigated at a subsequent retrial. Now,
your point is that in the case of collusion between sophisticated operators,
yes,
you're not going to see these things recorded in nice agreements.
indeed.
You've got to piece it together in little snippets
Yes.
which may occur. And you say, well, one of the participants here, we haven't got really any documents at all from them. So that's one bit of handicap.
Yes.
Now we're looking at other bits of the jigsaw, And this
Yes.
may have been one of the bits of the jigsaw which the judge found necessary to discount by making up a theory which he shouldn't have done.
Indeed. And the vice of that in a case like this, just imagine if the judge had been driven to the conclusion that this document of itself plausibly indicated collusion, and had said that in his judgment, one would be asking oneself, and I'm sure this court would be asking itself, well, what impact ought that to have had on other indicia, scrappy little documents, which the judge said weren't redolent of consultation or collusion with Vodafone. But if you look at those in a new prison, what does that tell you? And that is exactly why this sort of approach that the judge is wrong and creates serious prejudice to someone in the position of my clients. Can I?
Yeah.
I'm going to move on, my lord. I've got quite a few points to make. Ground 4, legal test. This is the Bilter test. Now, I'm going to try and rattle through this quickly. The court has seen Bilter. It's had my opening submissions. We've got fairly detailed written submissions about it. My learned friend, Ms. Demetrio, yesterday suggested there's some sort of freestanding need for an appellant to prove a causal link between delay and the error, and a particular error or omission, that she ultimately accepted. She wasn't particularly concerned with where the burden lay. In our submission, it's a key aspect of the test in Bilter that the default position in the case of severe delay, which unfortunately this case is, the default position is there is a causal relationship if we can identify misrecollection or omission of material evidence. In our submission, abundantly clear from paragraph 56 of the judgment, if we look at page 1257 of the bundle. And if we see, if the reviewing court finds the judge's recollection that it faulted no material point, then unless the error could not be due to delay in the delivery of the judgment. Not enough that the judge has meticulously reread the transcripts and so on, if he had omitted to consider a material piece of evidence. If we turn on to paragraph 58, and this is referring to the judgment in the St. Petersburg case, I think. Although in that case, both parties and indeed the Chancellor paid tribute to the comprehensive and meticulous nature of the first instance judgment of the judge's sheer hard work, it's found that his overall determination of the counterclaim is unreliable. Appeal was not determined solely on the basis that the judge had applied too high a standard of proof. He also found there were internal inconsistencies in the judgment, and the judge had failed to consider how certain findings made at an early stage impacted on his assessment of the key questions. He compartmentalised the case and failed to stand back and consider the effects and implications of facts that he had found taken in the round. Similar criticism made in the judge's present case, said the Court of Appeal there, and indeed in this case. And I should also show you paragraph 115 because it's relevant to the way in which my learned friends have approached this appeal. The judge did refer to the email to Mr. Metzler in his chronology, but he did not refer to it, all the other documents, in his treatment of the trader's evidence about the dinner. Those were documents which were material to the question as to whether the traders were deliberately ignoring and shutting their eyes to the existence of a VAT fraud and whether they were actually innocent in the sense that they they were wondering where this vast inflow of carbon credit had come from, and they made their own analysis of that. Now, can I invite the court to look at footnote 15 of our skeleton argument, tab 3, page 53. And there we refer to the statement of Mr Justice Snowden, as he then was, in his permission judgment in NatWest. And can I invite the court to read what the judge said there? Now, in oral argument yesterday, I think for the first time, it was submitted that if the permission judgment says something about a document and why it was or was not referred to, that is good enough to defeat any NatWest test. I'm not quite sure whether the submission is that the permission judgment should be relied on as the learned judge's recollection of what he in fact had in mind over the long period of writing the judgment, or it should be relied on as an after-the-fact analysis of whether the documents would have made any difference to the learned judge's conclusions. Either way, it's a bad point. Despite the submission which you see here, which was reflected in our skeleton, none of my learned friends have taken on the burden of submitting. The result in NatWest would have been different if only the court had taken on board what Mr Justice Snowden, as he then said in his permissions judgment, that he'd taken everything into account.
Well, would you agree that the result in Bill 2 reflects the court's perception of the materiality of the documents?
Yes. Yeah. Not what the learned judge said.
So, going to one of your points earlier, where you effectively... The court is required in those circumstances to look at evidence. You were talking about island hopping earlier, but in order to assess the materiality of any error, it's essential for the court to look at evidence, and obviously it can only be evidence to which the parties draw our attention, or it's in the judgment.
I accept that, but I caution my lady in the court to this extent, that what we can't have on appeal, in my submission, if we demonstrate that there was a material failure to address or recollect evidence, you can't then start saying, oh, well, you weigh this evidence against some other evidence which the judge did refer to.
No, I said assessment of the materiality. I didn't say
absolutely.
Doing a fresh...
Could, and the test,
could have made a difference. We've got your submissions.
Yeah. No, I'm going to try and rattle on. Landmark lunch. If we're right about ground one, we don't need to be concerned about the degree of passivity, or what the passivity of Dunn's evidence, what Dunn took was enough that it was a passive response. Now,
we do, don't we? Because you say it's part of the jigsaw with Dunn and...
I may have misspoke. What I'm going to say is, let's look at I'm not going to take you to now. The two documents are the Voda slide deck, which assumes that Voda will follow, and the chat message, text message, and you have my submissions about those. If the judge was going to reject our case on the inherent probabilities, he had to take into account these documents, which were regarded as significant documents by the parties at trial. As I said, Mr Hoskins at trial identified these as the three documents, two of the three documents which we had placed our money on, as he said, and despite his skillful attempt to sideline these documents, shorn of context, that's the clearest indication of what the parties regarded as relevant at the trial. There was a pleading point, I think, that was run by Mr Hoskins for the first time in this court in relation to timing. And perhaps we could look at the supplemental bundle, tab 131, page 1494. Where's it, which one? Sorry? Starts at the top of 41. Yeah, if you see in paragraph, page 41, line 13, I like to deal with each of those in turn. And two of those documents, the documents I've put before this court, one of the things you don't see in Mr. Hoskins's response is the pleading point, which he tried to take for the first time before this court. In any event, his pleading point is a bad one, and I'll give you the reference, and I'm not going to turn it up by reason of time, to our particulars, paragraph 131A, core bundle, tab 21, page 559. Now, this illustrates a broader point. As the court will appreciate, these matters were hard fought at trial. And the judge could have addressed this evidence and accepted Mr. Hoskins' submission. If O2 had any information about Vodafone, it would have been repeated in their internal emails again and again. What we say he could not fail to do is address those. As I've said, the witnesses were, of course, cross-examined in relation to the documents, and none of them offered the explanations that might seem superficially credible in argument as floated in this case. We do indeed say this court must be very careful not to be drawn into anything which smacks of retrying or reaching its own views on particular slivers of our case. The game changer slide, which we've looked at, assumes that Vodafone would follow, but it doesn't assume that Vodafone would follow immediately. And I hope you've got my point from the skeleton argument, that the contracts between these MNOs didn't necessarily have the same termination date. They were asynchronous. So it would have been important information to know what the strategic direction of these various entities were when it came to the time to think, can we get out of phones for you? Can I move to the our Intel document? That document only means what it says in referring to secret information heard by Vodafone specifically. It provides at least a strong indication that Ms. Rose had from someone within Vodafone insight into what O2 was likely to do. Specifically, whether the intel made it more likely O2 would do two things. One, come out of phones for you entirely, and two, align with Carphone Warehouse. And the straw man of our case, which we heard on appeal, is that we must contend that O2 must have promised never to enter into phones for you. That's not our case. Our case is that this our intel indicates that, contrary to the judge's findings, there may well have been a forward-looking conversation between individuals in O2 and Telefonica and Vodafone, touching on O2's strategy in relation to the indirects. We do not know what the judge would have found about the scope of such conversation had he addressed the document. And I've already, I think, made the point to the court that this was an important document from the perspective of our case. We referred to it in our roadmap I handed to the learned judge during my closing submissions at trial, and the judge simply ignored this document. Our roadmap said, what was our intel? That's core supplemental bundle, tab 8, page 41. Was the information limited narrowly in the way Vodafone now suggests? Or was it strategic information about aligning with one direct to the exclusion of another? That at least would arguably have continuing significance after an exit occurred. Now, Mr. Williams said yesterday, our intel document doesn't really matter because the judge found that in respect of any such discussion, the Anic presumption was rebutted. I'm afraid he is simply wrong about that. And if we can look at judgment 292, please, page on page 344. The judge says this: I consider at most Mr. Castillo told Mr. Hum O2 was doing fine, and that its move to reduce reliance on an indirect had not caused problems. This falls far short of any commitment as alleged by phones for you. I accept that while very vague, this may cross the boundary of anti-competitive exchange of information, and that may be why Mr. Hum was so insistent in his oral evidence that he had not raised the topic at all. However, since this does not involve disclosure of future strategy, I do not think it supports even the most general allegation of an anti-competitive conduct. But even if that had occurred, and I emphasise I make no finding, I consider that such unilateral passing of information could have had no causative effect on O2's conduct. Now, what the judge is talking about there is this backward-looking conduct, which he suggested may or may not have been passed between Ms. Castillo and Mr. Hum. But at most, as he says in the first sentence. Now, our case, which the judge did not address in the judgment, and Mr. Williams' point does not defeat, our case was that there was forward-looking information, strategic information, and the judge simply didn't address that point because he had ignored, amongst other things, our intel, which suggested there was forward-looking information. Now, one of the other things which was said to the court, and it indicates how careful this court must be, is in relation to Ms. Neymat's discussions with Ms. Castillo. And you'll recollect that Mr. Hoskins was submitting that, that there may have been no confidential information at all passing between Neymat and Castillo in relation to BT. And this is a great example of how far my learned friends are having to go on appeal beyond what the evidence showed at trial. Can I show you an extract from Ms. Castillo's cross-examination, please? Page 1472 in the supplemental bundle, forgive me. Page 112, lines 4 to 7. Yes, and I said to her, do you think you're going to talk to Ms. Neymat about British Telecom in the UK market? The answer comes, I would never have spoken to Claudia Neymat on British Telecom. Okay. So I then, on the next page, page 1, next page, 1. It's on 142. Keep going up. And I say to her, it looks like I suggest to you at a discussion of this name out on the 7th of October, 3 matters. Do you see that? I see the page, but I cannot tell you what is the meaning of these matters, yes. And how about in relation to BT? That even more, I don't understand the BT. Is it possible that it was Miss Neymat telling you that in reasonable conditions had been granted the BT in order for it to launch an MVNO in the United Kingdom? I wouldn't know, I don't know. You don't know. Now, let's then see how this was dealt with in oral closings. Supplemental bundle, tab 130, page 1489. Internal page 152, line 9. Yes. Can we have up the document? Your Lordship sees line 15, talking about a joint venture in Germany. And then I say, do you think you're going to talk to Miss Neymat about British Telecom in the UK market? She answered, I would never have spoken to Claudia Neymat, British Telecom. And then we look at Mr. Varela's note. It is Mr. Varela's note. Now, and then I submit. Now, when this was put to Ms. Castillo, she gave what we submit. I'm reminded this is the same day as a call between Claimant and Castillo, over the page. When she gave evidence about this in our submission, it was both implausible and defensive, and we can see a summary of that if you look at our closing submissions. We set out in the paragraph when the document was put. She floundered trying to explain this. And your lordship sees what she said, and I've shown that to the court. And the judge says, yes, she couldn't understand it, couldn't explain it. Now, that's just an example of how the court should approach with extreme caution submissions made that documents which were not referred to by the judge should be treated as immaterial, particularly in circumstances where it was dealt with at a trial and the judge simply admitted to refer to them.
Well, it goes further than that in the sense, doesn't it? Because if you read on, this was material which emerged during the trial.
It was.
After Mr Niemeyer had given
was.
evidence, and the judge makes the point, well, you couldn't cross-examine her.
Exactly.
So you couldn't get at it by another route, as it were.
No. And that's the problem.
By the other route.
The other route, indeed.
The other obvious route.
Yeah.
Yeah.
Now, can I then move as briefly as I can to the Sheen-Hum scenario? It was submitted yesterday, I think for the first time, that the judge found that Mr Sheen did not even communicate to Hum the specific topic which he wanted to raise. That is flatly contrary to judgment 570. Can we have that up, please? Page 421, full bundle. And we see that the learned judge thought it was inconceivable that Hum would not have asked what was the topic for the UK market Mr Sheen wanted to talk about. And he does go on to say he may not have entered into many details. Hum accepted in cross-examination he must have learned enough about the topic to think that it was worthwhile having a meeting in London, where Hum was based, in short order. Now, Sheen wasn't based in London. There was a sort of suggestion yesterday, and I'm coming to this, that Sheen was part of the Orange M&A team. Sheen was a very senior man in the Orange organisation, head of Orange Europe. He happened to be a director of EE as well, but he's not based in London. So he's going to come to London in short order to discuss this topic for the UK market. And when he can't, he proposes a conversation with Mr Hum on burner phones. Now, Mr Hum, having learned enough what the topic was, he agreed it was worthwhile following up in short order. Having found that Sheen would have told Hum at least some details, everything the judge said after that about what exactly Sheen might have said obviously depended on what the topic was. And in our submission, if the judge disregarded, as he did, critical evidence in his consideration of what that topic was, it's impossible to assume taking a different view on the proposed topic would have had no impact on what the judge concluded as to the import of what was said. So, test the point by our submission. Suppose that the supposed topic was the exiting from phones for you because the circumstances of the merger had presented a unique opportunity for EE to negotiate a better term with Carphone, get rid of the hated revenue margin share, and extricate itself from phones for you. Let's assume that was the topic. I've said that in about 30 seconds. It wouldn't have taken Mr Sheen long to explain what the topic was. The real point is, did the judge disregard evidence which hinted strongly what the topic was? And in our submission, he did. Ms Demetrio appeared to suggest that the fact that Mr Nullo sent an email to Mr Sheen 2 days before his before his conversation with Mr Hum was insignificant. Mr Sheen's evidence was that he in fact read the email probably a couple of days after its receipt, 31st of March, which would mean that on the very same day as he reached out to Mr Hum, he was proposing to have a conversation which he ultimately described as an interesting joint opportunity. In our submission, what prompted Mr Sheen to contact Mr Hum like this was plainly critical evidence and the judge did not refer to the passing on of this email from Mr. Nolot to Mr. Policier on to Mr. Sheen, simply ignored it. As I pointed out on Monday, it ought to have featured, this episode ought to have featured, at least in the chronological terms, after judgment, paragraph 467. And if we just get that up, just to make that good. So you see, on the 31st of March, Dannenfeld spoke to Policier. They're internal. One's Deutsche Telekom, the other's Orange. Neither could recall the conversation. And then we go on in the week prior to the 10th of April, BRM. Sheen's conversation with Hum falls firmly between 467 and 468. But reading this chronology of the judgment, you would simply not know that this episode had taken place. And instead, the judge relegated it to the back end of the judgment under a heading, a series of unfortunate events. Now, Mr. Demetriou remarkably suggested to the court yesterday that somehow Mr. Sheen had been tasked by EE to investigate the possibility of a joint acquisition. It seems almost odious to point out that this was no witness's evidence. Forgive me, Orange. This was no witness's evidence and nobody's case. In any event, the idea which has been deployed against us in this case is preposterous. Orange's M&A team was never tasked with making an approach to Vodafone. Sheen was not part of Orange's M&A team. There was no suggestion that he was even in touch with it. He was the head of Orange Europe. There were no disclosed documents supporting the idea that Sheen was asked to make any approach or reported back on the outcome of the approach. So, the question one has to ask is, bearing in mind the absence of any request or instruction, was Sheen so enthused by the idea of a joint acquisition that he decided to take upon himself to investigate the opportunity in a covert and unorthodox manner? And that is where the tranche of disregarded evidence comes in. That evidence showed that nobody within Orange, including Sheen himself, was interested in a joint acquisition, let alone being highly enthusiastic about it. In relation to this material, Mr. Demetriou says it was all taken into account in the narrative or chronological section of the judgment. But there's a twofold problem with that. First, Nat West makes clear that the critical question is whether the evidence was taken into account in relation to the topic to which it was material, i.e. the subject matter of this approach. None of my learned friends acknowledge the point from a NatWest perspective, and the point has of general application, particularly when one looks at paragraph 573 of the learned judge's judgment, page 422, where he says, I think it is important to consider this exchange in context. We wholeheartedly agree. However, and it can't be any clearer from what the learned judge says here as to what the context is which he's taking into account. That evidence did not extend, although he referred to the BRM, the evidence did not extend to Mr. Sheen's comments made at the BRM, not in wholehearted support of a joint venture acquisition with anyone, but suggesting it might be good to exit from Phones for You. If the learned judge had had those comments in mind when considering this issue, it might have cast a very different light on what Mr. Sheen was about. Never mind what directors of EE might have been considering, Mr. Sheen was very clearly interested in an opportunity to exit Phones for You. Next, it's wrong to suggest that all the material was referred to in the narrative section. Most of it was not. Critically, Sheen's evidence in chief was that he was sceptical. That wasn't referred to. Nor did the judge refer to Sheen's evidence in cross-examination that an acquisition would not have been his preference. Supplemental Bundle 3, tab 120, page 1454. We ask rhetorically, How could that evidence and machine not be an important context when the judge was coming to decide whether he took it upon himself to pursue the idea of a joint acquisition in this extraordinary way? Now, I'd like to go to the email sent which is at Core Supplemental Bundle 23, page 69. And if we could scroll...
And this is the 31st of March.
That is the 31st of March, yes. 2 days before Mr. Sheen contacts Mr. Hum. Over the page. And this is something that, an aspect that Ms. Dimitri or Mr. Pickford, whoever addressed this, didn't specifically draw to the court's attention, but I think I have already. You'll see the indent, first indent. We thus note a scenario for EE to explore. Negotiate our support for the merger with Carphone in exchange for an end to RMS, and they withdraw from EE distribution at Phones for You. So we, Orange. EE is more inclined to analyse, with the support of M&A shareholders, a scenario of acquiring Phone for You, possibly with Vodafone, and then sharing and rebranding the stores. In this regard, during the controlling review at Paddington, Madame Lambert does not support at all a scenario of acquisition, which O2 has just left, but on the contrary recommends to move forward on a costed analysis of a more breakaway scenario, stopping RMS, Carphone, and withdrawing Phones for You.
Also, there's the point you didn't read. I understand from Wolfgang, Thomas D's position. So that's Deutsche Telekom.
That's Deutsche Telekom.
First and foremost, do everything to weaken the excessive weight of indirect distribution in the UK.
Yes.
Which suggests that there's an aligned approach between Orange and
Deutsche. They're the controlling shareholders.
Even if he disagreed.
Even if he, the evidence was clear when we went at trial that Deutsche and Orange were against the idea of any acquisition. Orange much more so. That's true. But they humoured EE, in particular Mr. Swanty, who seemed to have a bee in his bonnet about a potential acquisition. They humoured him. But there is simply no basis in the context that the judge refers to in 573, never mind in the rest of the narrative chronology, to support the proposition that this was all about a joint venture acquisition. This finding was in disregard of critical evidence, which could make a big difference. Now, I see the time. I've got a few more submissions to make.
Okay. If we can finish by 1:15 on the clock.
Go for my lord. Modelling. My learned friend Mr. Pickford dealt with that today. Now, I already showed the court at the beginning that, from our perspective, the critical element of this was the, you'll later recollect, I talked about handset cost efficiencies. And it's nothing to do with a misrecollection by Mr. Eyre. Mr. Eyre's evidence was clear that unless there was going to be an exit from Phones for You, he would not have been modelling handset cost efficiencies. Yeah, unless Phones for You was either going to leave or be a substantially reduced presence in the market. That was Mr. Eyre's evidence in chief, and the judge simply disregarded that evidence, because you will have seen from judgment 520 through to 522 that the judge thought that the dramatic change in EE's approach occurred following a cash flow analysis that my learned friend referred to. In fact, if the judge had borne properly in mind the evidence of Mr. Eyre, the court would have seen that it was the assumptions changed dramatically, including handset cost efficiency on the 5th of May.
Well, the number was in from earlier in the year, wasn't it? But on the basis of an acquisition.
Correct. And the significant...
Your point was it moved from an acquisition to an exit.
Exactly. Because if you take out Phones for You by acquisition, then you don't have the competition from Phones for You. But if you exit, well... Now, there was a lot made by Mr. Pickford, and I can essentially take it quickly. Look what Mr. Eyre was doing. Mr. Eyre's modelling isn't relevant of the possession of anti-competitive information. Yes, well, that may be right. We did not suggest that Mr. Eyre was within the circle of collusion. There's no need for Mr. Eyre to be brought within the circle, and you might think that plausible deniability might be improved by not letting everyone in on the secret. So it's nothing to the point to say, oh, look, Mr. Eyre's cash flows say this, Mr. Eyre's cash flows say that. That's not the important point. Our important point was that following his discussions with Milsom and Alera, he suddenly started assuming handset cost efficiencies, which are, as he says in his evidence, only consistent with Phones for You either not being or no longer being in the market. Now, can I move on then to Dunn Lawrence under Ground 5? It's a compartmentalisation point. Mr. Williams took a simple approach of disputing that there was a very close link between topics of 4G pricing and supplies to indirects. First problem with that is that the link is abundantly clear from the material referred to in the judgment, to which I've already referred the court. He argued that there was a large disconnect between the two topics, and he says that the one involved collusion with an indirect, i.e. price fixing on 4G with the help of Carphone, and the other involved colluding effectively against an indirect, namely pulling volumes from Phones for You. Whether pursued against or with an indirect, the two forms of collusion still aimed at the same objective, namely preventing price discounting by indirects in response to the launch of 4G. And we say the learned judge had to take into account the very close linkage. He failed to do so. Mr. Hoskins took a different course. He seemed not to dispute the close link between the topics.
That's not quite fair. I said I wasn't going to go into the reasonableness of the decision because I said it wasn't ability.
Well, whether he was or he wasn't, there's a compartmentalisation problem here. Because if one looks at the material in Judgment 158 and then asks, could the judge, if he had had that in mind, come to the conclusion in Judgment 239 that there was no chance of collusion between Dunn and Swanty because these were discrete topics. If he had properly in mind the fact that they were closely related, he couldn't have come to that conclusion. Now, the Whiting note. In our submission, it was essential when considering the veracity of the Whiting note to bear in mind two things. The truth of what Mr. Dunn said must have made it more likely that the rest of it was true. Second, if what Dunn said was not true, it would have been an extraordinary coincidence that at the one meeting between Hum and Castillo, which we discovered as a result of a disclosure, two of the executives that were mentioned in the note, i.e. Hum and Castillo, actually did discuss O2's relationship with Phones for You. Now, the answer to this point was said to be, well, Phones for You's own witnesses thought that what Dunn said was odd, and it would have been just as surprising for him to say it if it was true. But there are two problems with that. First, Phones for You's witnesses were operating with materially incomplete information. They did not know what Mr Dunn said about Mr Swanty was at least approximately true. They did not know what Dunn said about Castillo and Hum surprisingly closely tracked what had actually happened. Our second point is this: even in their initial reactions, Phones for You's witnesses never posited that Dunn's statement might be part true and part false. That obviously was deeply implausible, and nobody's given any reason why that would have happened. In considering his findings in the round, the judge at least ought to have considered this point. She have taken into account the remarkable coincidence of what Dunn said and the fact that Castillo and Hum did meet to discuss Phones for You. Now, Mr Hoskins said that the judge did, but if we look at paragraph 311 of the learned judge's judgment, we see that the judge did not. 311 on page 349. Forgive me, paragraph 311, 349. I've considered carefully what impact my finding that the conversation indeed took place has on the assessment of what Dunn said was true. In my judgment, it does not affect the determination. All the reasons for holding the alleged collusion between Telephone and Vodafone most unlikely, as Mr Lloyd pointed out. Now, it is true, he does consider what impact the fact that the judge, that Dunn had said it, has an impact on whether he said what he said was true. He does not consider instance of compartmentalisation, what effect it ought to have on his determination that Hum and Castillo had indeed had a discussion several months before on precisely the topic of the exit from Phones for You. My final point, the minutes of the meeting of the 21st of May. We put this on the two bases, but I addressed the court under compartmentalisation in ground 5. We rely on the fact that when it came to being extra cautious about the topic of indirect steps, next steps, Mr Blendis was asked by Mr Harris, the creator of the minutes, to consider whether it had been appropriately captured from a competition law point of view. As my learned, as Lord Justice Phillips rightly said, here we have a scenario where we see Mr Harris being ultra cautious, even more cautious on the 21st of May, when extraordinarily there is no setting out of what actually was discussed. And the final point on this is this. Going to see Ofcom to allay suspicions that might otherwise arise as to whether the closely timed exit is, in our submission, part and parcel of the same conduct. And the judge ought to have taken that into consideration and not reached the conclusion, as we know he did, before taking that into consideration. My lord, I've run out of steam, and I'm sure the court has as well, and I've now passed the
Very well.
time.
Well, thank you very much indeed. At an earlier stage, we did talk about possibility of any written submissions and rebuttal. I'm not shutting anybody out from that if you think it's appropriate. But if there is going to be any further written material, please within 14 days. Next week's a vacation, as you know, so I'm not forcing you to do something if you're going to be on holiday. But if we can have them by whatever 14 days from today is 6th of June, have I got that right? I think it is. So by 4:30 on the 6th of June, please. Anything else? We're obviously not going to. You're not going to get a judgment anytime soon.
Not too long.
But don't tempt me.
My lord, before court rises, may I clarify in relation to what aspects you are permitting.
No, in relation to what was said when Mr. Bailey went slightly over the top, that's all I had in mind. I think you've been very careful not to sort of, as it were,
Wily or otherwise.
wily or be too wily. No, I mean, we will obviously let you have a judgment as soon as we possibly can, and we're acutely conscious of how serious this is, however. It will take some considerable time, I'm sure. It only remains to thank all of you, and we appreciate that it's always teamwork, so it's not just the people who've spoken, it's all the people who are behind, the juniors and the solicitors and the clients. And just thank you very much for what has been an extremely well presented appeal, and actually in all the circumstances extremely good-tempered as well, which is a tribute to all of you. This is the way in which, and the professional way in which these sort of cases should be presented to the court. It makes our life a lot easier if we don't have sort of bickering going on. And just finally, I want to say, because I was a bit sort of terse about Opus 2 at the outset, I just wanted to say that thank you very much to Opus 2, particularly whoever it is who's presenting the documents. That was done in an incredibly professional and quick way. I was absolutely staggered at how that could be done. So thank you all very much indeed.
Thank you, my lord.